Donnie Allison. And that was the first legal statement of the Zoom recording. So you all agree to that, right? You all agreed to it.
Yeah. Just clicked on it. I agree.
Well, it's great to work with Donnie. We've been working together for many years now, and it's great to have his wisdom. And so I'm really grateful for everyone who tuned into this webinar tonight, because 40 years into being a priest, 42 years into being a priest, 10 years into being a bishop, I'm learning from Donnie all the time about things that are really important to our church involving canon law. And Donnie's not only important to our diocese, but he is the church attorney, not the chancellor, but the church attorney for all the other dioceses in New England. So he's in regular correspondence with our faith leaders. So Donnie, we welcome you.
Thanks. I'm really glad to be here. I mean, maybe as a start, I could, since Doug talked about the two hats that I wear, one as chancellor for this diocese and the other as church attorney for all of the other dioceses in Province 1, perhaps a good place to start is to describe the difference between the two. The chancellor is defined in the canons, including our canons for our diocese, as essentially a lawyer who's appointed, and in the case of our canons, appointed by the diocese. Some dioceses, the chancellor is, according to their canons, like take Connecticut, the chancellor is actually the lawyer to the bishop. Our canons actually say I'm appointed by the diocese, and it's kind of a fair reading of that to say that I'm the lawyer for the diocese. Now, in 99.9% of the times, there's no real distinction since the bishop is the head of the diocese. There are some very, very, very few instances where there could be a conflict between the bishop and the organization, the corporation that is the diocese. And in that particular instance, there would have to be a separate lawyer for Doug. I've never seen it in our diocese. I don't anticipate it ever happening in our diocese. But in my profession, it's really important to be clear as to who your client is. And in our diocese, my client is the diocese. Like I said, Brad Babbitt, who's the chancellor for the Episcopal Church in Connecticut, his client, according to their canons, is the bishop and not the diocese. In any event, the chancellor is essentially, in our instance, the lawyer for the diocese. The church attorney is a position that is defined in Title IV of the Constitution and Canons of the Episcopal Church in America. And Title IV, as probably most of you know, are the disciplinary, is the disciplinary canon in our national set of canons. And the church attorney is responsible for representing the diocese in disciplinary matters. As Doug could probably tell you, and as occurs in situations where I am working in other dioceses, it does not mean that the chancellor to the diocese is not involved in advising the diocese or the bishop in certain Title IV proceedings. But the advice is a kind of advice to the organization and not the representation of the organization in the actual disciplinary proceeding. And Title IV, as some of you may know, has a series of steps that get followed. Investigations, conference panels, and ultimately if it's not resolved, hearing panels where there's an actual trial, an actual calling of witnesses, a panel that then makes a decision on the facts, and a decision on the penalty if a violation of the canons is established. So that I hope that helps you understand the difference between church attorney, which is purely involved in the investigation and prosecution in ecclesiastical proceedings of clergy discipline, and Chancellor, who is the lawyer advisor to the diocese or the bishop in all sorts of general matters. Maybe another, easy thing to talk about, because it's something that many of you will be experiencing in the coming months. As a lot of you know, and this is a particular legal matter or legal program that we are undertaking here in the diocese. As I hope all of you know, our canons and the national canons require that if a parish is going to sell property or encumber property, and encumber is a very, very broad definition. And I think the easiest way to look at it is the way my property lawyer taught me my first year in law school. If you look at a property, real estate, as a bundle of sticks, if you have all the sticks, you own the property in fee simple absolute. If you give out sticks, a mortgage to a bank, an easement to to a neighbor, a lease that is a lease of the nature of being recorded, you will have given away pieces of your property. If a parish is going to give away a piece of its property, it needs standing committee and the bishop, what we call ecclesiastical authority, to actually give away that piece of property. Also, the canons are really clear, because oftentimes these things go hand in hand. If a parish wants to borrow money, indebt itself, it needs standing committee and ecclesiastical approval. This kind of winds back to the fact that I think most of you know, but maybe you don't, that in every registry of deeds in Western Massachusetts, there is a piece of paper filed that essentially says you all, as a parish entity, hold the property you own in trust for the diocese. It is not yours to give away as you see fit. You have given away a piece of it, if you will, or the diocese has claimed a piece of it, like that whole stick thing, and it's on record. So if you tried to sell a piece of property without getting standing committee vote and ecclesiastical approval, the bank would, the buyer would not buy it from you, because they couldn't get title insurance, because there'd be a title defect, because you need standing committee and ecclesiastical approval to do it. And two, you'd be in a lot of big trouble with us, but leaving all that aside. So that means that there's a process that everybody has to go through, that these individual parishes, and I think I ought to tell you that if you are the senior warden, you are, at least as far as Massachusetts is concerned, the president of the entity that is your particular parish. So it's important for you all to realize, as you're going down this path, whatever path it may be in terms of borrowing money or selling a rectory or any sort of real estate transaction, to get in touch right away with me so we can begin the process, or Rich, actually. Don't bother Doug with it, but you can bother Rich all you want. And so we can begin the process of doing that, because the standing committee only meets periodically, and the ability to put together the appropriate votes and get the appropriate certificate, which we'll get to in a minute. The earlier you get started on it, the better. You don't want to delay your closing because you ran to us with 3 days to go till you close and say, oh my gosh, the bank's lawyer says, we can't close this deal because you haven't gotten standing committee approval. Backing into this a little bit, one of the things we've discovered, and I see Tom Doherty here, and I know that a number of years ago, when Grace Church was borrowing money to renovate part of its facilities, the banks were pretty, I don't want to say loose, but they were not as strict as they have become post 2007 and the market crash. I don't want to trace it directly to Dodd-Frank or any of the regulations that came as a result of that, but banks are now being I dotters and T crossers. So whereas, because Grace Church here in Amherst, I'm looking out the window at it actually, because Grace Church in Amherst holds its property in the name of the rector, wardens, and vestry of Grace Episcopal Church in Amherst, the bank was perfectly happy to have a deed signed by, the senior warden with the authority of the rectors, wardens, and vestry of Grace Church Amherst. In more recent times, banks now require a piece of paper from the Secretary of the Commonwealth's office that basically says you exist as a corporation here in the Commonwealth. And for years and years and years, you were just kind of deemed corporations. And like I say, banks were pretty loose about what they would accept. Nowadays, they're not. You've got to produce what's called a certificate of legal existence. And the only way you can get a certificate of legal existence is to be listed on the Secretary of the Commonwealth's database as a corporation, as a legal entity. Because after all, that's the authority that you have to sell this property. You are a legal entity with the authority to sell, a corporation. You've gotten the approval of the lien holder, if you will, the diocese, to sell the property. And now you can convey good, clear, marketable title that a bank will issue a loan on, that a title insurance company will insure for the borrower. You can get all of that. Because historically, and I'll take you on a little historical, in the early days, when a parish, and I'll just pick Vicky's parish up in Ashfield, in the early days when St. John's in Ashfield was established, they were actually established by a specific act of the legislature. That St. John's in Northampton the same way. You exist, the legislature created you as a corporation back in 1810 or 1820, or in the case of some of ours in the Berkshires in the 18th century. The Protestant Episcopal Society in Sheffield, the same in where Doug lives. All of those were created by specific statutes. They are listed in the card file of the Secretary of the Commonwealth's office, but they are not listed in the General Laws, Chapter 180, which is the nonprofit corporate statute. They are not listed in the database. And so if a bank or a lawyer or a title company goes to look up Grace Episcopal Church in Amherst, they will not find it on the corporate database. They will not. And they wouldn't have found St. John's in Ashfield because it's in the card file. It is now in the database, but back, a number of months ago, it was in the card file. So we have embarked on a program here in the diocese to make each and every one of your parishes a corporation. We'll get to Grace down the road, Tom. There are a number of them that are selling pieces of property right now so that they kind of go to the top of the list to create them so that they can actually transfer their property. And that's a process for those that don't exist. It is a process of preparing a petition under Section 9 of General Laws, Chapter 180. And again, Chapter 180 is the nonprofit corporation statute in Massachusetts. Section 9 there's a section in that statute that says, if you're a religious organization and you have acted as a corporation for a period of years, we will deem you a corporation. We will officially deem you a corporation. You will then be on our database as a corporation. And that petition, which gets signed by every vestry member, basically says, here's how we've acted as a corporation. A group of us got together in Grace's case in 1864, 65, whenever it was, and we decided we were going to create a parish. And we started to have the two things that corporations have to have. They have to have an annual meeting of the corporation, and they have to have meetings of the directors of the corporation. So here you go. We've got representative samples of our annual meeting from 1910 and our one particular set of vestry minutes from 1910. And you pick out kind of representative samples of an annual report and one set of minutes of a vestry. The earliest one you can find is going to be when the Secretary of the Commonwealth deems you became a corporation. And we always have to have the latest one because they want to see that you are still operating, and they want to see that you take in money and you spend money. You otherwise do all of the acts that a corporation would do. That petition gets filed with another document called a restated articles of organization, because in modern times we have articles of organization, and you get a modern set of, and by the way, they're form, because you can't have your own bylaws in our diocese. You are bound to our constitution and canons and our bylaws. Some states, every parish has its own set of bylaws. We don't. It's a pretty simple form that gets filed. And if let's just use Grace as an example, not because I want to pick on Grace, because that's my parish and I'm familiar with it. We would probably get together and say, do you guys really want to be called the Rector, Wardens, and Vestry of Grace Episcopal Church in Amherst, or do you want to be called Grace Church Amherst? And then we can change your name to Grace Church Amherst, so you don't have this enormously complicated handle that you're working on. That's the process we're going through, but it's a process that requires from you all helping me gather documents. And some of you know Steve Abdow, who's actually helping me on this process. Probably most of you know Steve Abdow. and he will, in the coming many months, because it's going to take a long time. There are 45 or so of us that are not incorporated at this particular point in time. He'll contact you to begin to put together that process of creating you as your own separate corporation. I do not want to confuse you. You still use the diocese tax charitable tax ID. Doesn't have anything to do with that, but you will exist as a corporation. That's the biggest process that we're going through now. That's a lot of what I do. There are other things out there, and I don't want to open the floodgates on this, but there are other things out there that need, and I was talking with Rich about this morning, and Doug knows too. A lot of you have old restricted endowments that you want to lift the restrictions on because, guess what? We don't do this anymore, that this restriction says this is limited to. And again, because you're a charity, because people can donate to you and get a tax deduction, you are regulated by the Attorney General's Office, Division of Charities. And it's not, gee, I don't want this restriction anymore, and we can get rid of it in 5 minutes. You got to have the Attorney General's Office, the Division of Charities, get on board. If it's a lot of money that you've got in this restricted endowment, you may end up having to even go to court and have some sort of a judicial determination lifting the restriction. And that happens in cases. I mean, there are some, and I can tell you that I worked on for St. John's in Northampton, where the deed to St. John's said, if you ever stop being a church, this property reverts back to my heirs. So you got something given to St. John's in 18 whatever. You can imagine what it's like to track down the heirs of this family from whenever. And the bank won't lend the money for the construction they're doing without a clear title, because they're going to take a mortgage on the property in order to give them the money to build their addition to their campus. And in that particular case, we had to actually go to court. We had to publish in newspapers, hey, any heirs of this family, speak now or forever hold your peace. It's kind of like a wedding. And then ultimately the judge got rid of that remainder interest going to the heirs. So there are legal issues like that pop up totally unexpectedly that you don't even necessarily know are there till you begin to want to do something like borrow money or sell something. And that's when you need to contact the diocesan offices, and they'll contact me to work through some of that stuff. And it's the same thing in a much smaller case with restrictions on endowments. There doesn't tend to be, there's, the diocese has one where there's an endowment for, orphaned girls, which presumably, 80 years ago or 100 years ago, the diocese was doing work with orphanages in and around Western Massachusetts that they're not doing anymore. And so, can we release that restriction? That's the major stuff that I do. There's always little things that come up. I want to encourage all of you, if you are going to either, I don't think you should be leasing out stuff. I think you should be giving entities that might want to use your facilities use agreements as opposed to leases, which is simply a contract. It's not really an interest in property. It's just a contract that says you can hold your meeting in your facilities. But I really want to urge you to make sure in all of our efforts to do good works that we make sure our insurance is in place. That in the case of some organizations that might want to use your facilities, that they have their own insurance, especially if it's a big thing. I know it sounds like it's a hassle, but if you've got a parish hall and somebody's going to have their wedding reception in there and they're going to serve alcohol, and you just need to make sure all of your I's are dotted and all of your T's are crossed, because it's a disaster down the road. They should have their own insurance, and you should make sure they have the particular rider that applies to those sorts of events. And maybe you shouldn't even let them do it at all. I don't want to be a proponent of, letting people have alcohol necessarily in their parish halls. That's your choice. But my advice to you is make sure you've protected yourself insurance-wise. Yeah, Tom.
Hey, Don. So, well, for when we have vendors come into the church to do work, we ask them for their COI, certificate of insurance.
Exactly.
Is there a particular aggregate that we're looking for? $1 million, $3 million? I mean, we've got roofers, we've got plumbers, we've got electricians.
You get roofers that could fall off a roof. You get, and trust me, there'll always be some argument that there's something, there's some defect in your property that contributed to them falling off the roof.
Right.
I would basically say most of the time I see either 1 million, 2 million, or 2 million, 5 million, depending upon, but I think that's more than enough.
Okay.
But you should definitely have it. Definitely.
Right. Okay. Yeah. Thank you.
Just let me say a word about that too, is that if you ever have a situation like that, you can always contact your representative at Church Insurance, and they can talk with you about limits as well.
Yeah, I can't emphasize enough having appropriate insurance.
Yeah.
I will tell you that there's apparently a $25,000 limit on recovery against a charitable organization by statute, but that is there are more exceptions to that than there are holes in the colander that you put your spaghetti in when you're rinsing it out. There are many ways around that charitable limitation. So plus the other thing is if you have insurance in place, they also hire you a lawyer to represent you in the event that you get sued. Because insurance policies have two things. They have a duty to defend and a duty to reimburse or pay a judgment. And the duty to defend, the threshold on the duty to defend is very, very low. Doesn't take much, just takes an allegation of negligence to trigger the duty to defend.
Don, I was just going to say, because I've heard you say it a million times. By the way, did everybody notice Don and I are wearing the same shirt today? I don't know what to make of that. I just want you to know that we are. But I noticed it this morning.
It's true.
It's true. But the issue of hold harmless agreements, I've heard you say many times, are not worth the paper they're printed on. And I think that's a good thing, because a lot of times churches get used for good causes, perhaps, and people think if they just sign that, then they don't have to worry about the other stuff you're talking about. And I just thought you might want to take the opportunity to reiterate that with this group here.
Yeah, that's very, very important. You cannot contract away your liability for negligence. You cannot. So those hold harmless agreements, or whatever agreement, the whole theory behind them, the reason people have you do them is not because it protects you. but legally, because it doesn't protect you. But it may, and this is a little disingenuous. I mean, it may, the person who signed it, who got hurt, may think they can't. They may think they've signed away their right. But legally they haven't signed away their right. It's more like that. And there's some things that you can't sign away. I mean, that even we can't. I mean, there's something where there's strict liability. There's not even negligence. Dog bites, strictly liable, period, the end. No, gee, they teased my dog. Dog bites, you are liable. So yeah, that's very good, Rich. You really do need to understand that just having somebody sign a piece of paper saying, we realize that we are going to be involved in activity which could result in blah, 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 blah. We hereby hold, the parish harmless from any and all claims. Can't do it. It's as a matter of law, it is a void protection piece. You can't.
Don, we seem to be in question and answer zone already. Did we keep you from?
No, I mean, that's the bulk of what I do. I mean, you all know that you've got people in the diocesan office. You've got Susan, who works on payroll and employment and those sorts of issues. There are some parish issues. And I want to be clear with you all that I don't represent the individual parishes. I represent the diocese. There are some circumstances where an issue is of such importance to the diocese that they will have me represent you, and then it won't cost the parish money to hire their own lawyer. But those are not, every time you have. I mean, I'm generally willing to answer a legal question for pretty much any parish. But if you want to sell your property, generally speaking, the diocese doesn't hire me to represent you to sell your property. You get your own lawyer to do that. But no, I mean, if there are any questions or anything people want to know about what I do day in and day out, I'm more than happy to answer them.
Well, let's shift to gallery so you can see everybody.
Hey.
And we can see who has a question for Donnie. Susan Howland.
So I was going to shift a little bit from building sales and encumbrance and liability to a question about canons. So this question comes up a lot. Are priests voting members of the vestry?
Generally, no.
Are they tiebreakers?
Generally, no.
Are they voting members in the annual meeting?
I don't know the answer to that. But the vestry is the entity. The priest director is not the president of the corporation, and doesn't hold an office. The rector is more like a chief operating officer, not a corporate director. I mean, the vestry is a director. They are the legal representatives of the parish. An officer kind of runs. You could, in some instances, you can be both. You can be both the president, an officer, the senior warden, an officer, and also a member of the vestry. You can be the treasurer, an officer, and also a member of the vestry. You can be a clerk, a secretary, and also the member of the vestry, but you don't have to be. I mean, nobody has to be both. And if you are both, you are listed on the corporate listing as both an officer, in Tom's case, for example, president, and director. Senior warden, basically the way it'll be listed on the form is senior warden power of the president, and then director. The rector can be the chief operating officer. The rector can even preside at the vestry meeting. But generally speaking, the rector shouldn't be a voting member.
Okay. And I learned the hard way, the rector is also not a member of the parish. They are.
That's correct.
And I think their spouse is sort of ambiguous. Do you have a call on the spouse? If they choose to move their membership to the parish, that their spouse is.
Yeah, the spouse can be a member of the parish.
The spouse can? Okay.
Yeah. I mean, the rector has a contract between the parish acting as the vestry and the diocese. It's a 3-part contract.
Right.
I don't want to get Title III, but Title III basically of the Constitution and canons of the Episcopal Church governs the rector and the clergy person's relationships. And I'm happy to look at that closer. I think it's I can look closer to see if a rector could be a voting member of the vestry. I think it's better practice for them not to be a voting member of the vestry.
I looked at the canons and there wasn't anything there, although it does say that the vestry is comprised of the officers. So I was curious about them also being listed as members. We're one of the parishes that was incorporated, and in the card file, 1921.
Which parish is that, so that I know?
Holy Trinity Southbridge.
Oh yeah, I just incorporated you, and you're not just in the card file. Pretty soon, stuff got sent in, and you'll be in the corporate database.
Right. Yeah, I've been working with Steve on that, so we're one of those parishes that was incorporated. But I know where I was going with that. Yeah, but it's a question that comes up a lot. Not that we're usually roundtable, consensus model, but when it comes to the hard question, sometimes you have to vote. And I just was wondering what the canons said about that. Nothing.
If you backed away the logic, so if you looked at this kind of the logic of it, we all know that. I mean, the way a corporation works is the members of the corporation. And in the case of parishes, the congregation essentially has an annual meeting, which is like an annual meeting of shareholders. Okay, we're having our annual meeting, and liken it to an annual meeting of shareholders, and we vote directors. We don't vote rector; we vote directors.
Right.
And they're the ones that vote, that meet and take votes to act on behalf of the corporation. And that's the best way to look at it. Vestry meetings are directors' meetings. Annual meetings are shareholder meetings.
It's just that the canons say that the rector or the priest will lead the vestry meetings, so it gets a little.
Yeah, you can preside over the vestry.
Preside. Yeah. Okay. And I have one more question. I probably other people might have this as well. So, and that's about electronic voting on Zoom. Are the canons going to get changed?
That's a good question. I can tell you this because I am on committees. I'm on a town committee, the Energy and Climate Action Committee in the town of Amherst. And in Massachusetts, that we are still allowed to meet and vote electronically.
Because Governor Baker, because of COVID?
That's right.
Yeah.
And that hasn't been rescinded yet.
Okay.
But at some point it'll be rescinded,
Yeah,
or maybe not. I mean, maybe we've become such a, such a Zoom world, that it'll get written in that we can permanently have meetings electronically. But right now, we can still meet and vote electronically.
okay.
That it's an interesting. Again, I don't want to get in the weeds in this, but under Massachusetts exemption, and Doug and Rich and I, we've just broadened this for the purposes of our Zoom meeting. But our Zoom meetings and the ability to vote, technically, the elimination in the necessity to meet in person for directors has been lifted for corporations.
Right.
Technically, many of you are not corporations yet. And so technically, I suppose there is the possibility of that. If there was any concern about it, and if anybody, if for any reason had any concern about it, one of the things that are available to corporations after the fact is, after you became a corporation, if the need ever arose to deal with a vote that you had taken when you weren't a corporation electronically, you could ratify it. You could ratify the action that was taken a year ago, and that would kind of tie that up, legally tie that up in a bow for you. So you can always go back and ratify an act that has already happened.
Right.
I think Tom Doherty, did you have a hand up?
You're muted, Tom.
Yep.
Oh,
Okay. Thanks, Don. So at some point we'll all be incorporated, and there's no rush, at least not at Grace Church that I know of, to do that just yet, but at some point we will. And the main reason, or one of the reasons, is because of the buying and selling of land, which again, Grace is not doing any of that right now. Is that correct? Or I mean, are there?
I mean, there are a variety of things that sometimes people want to do. That's the main reason, Tom.
Okay.
You're absolutely
Yeah.
right.
All right.
Anytime
Just want
you
to
have to deal with
double
a bank
Yeah,
or a
right.
title insurance company, and because in that case, the buyer, because the buyer is only going to buy your property if they can get title insurance.
Right.
Anytime you're dealing with that. But there are other smaller things. There are situations where maybe parishes have thrift stores that they want to get a business certificate from the town. Now, you can get one without being a corporation, but it's a whole lot easier if you're a corporation.
Okay.
To be able to do business in the town. Yeah.
Thanks, Don.
We still have 10 minutes to play Ask the Chancellor. Okay, Mary Frances.
Oh, Mary Frances.
Yeah, Don, we're going to talk soon.
Yeah.
I have a question about, we have an awful lot of groups that use our building, and one is for, all year through, they use it for their meetings and their ceremonies and things like that. I'm concerned that we might not have the right language in our use agreement, our building use agreement. And I'm just wondering if there's access to a copy of something where we need to make sure that we have the right terminology so that it's clear on both sides what the expectations are, et cetera, et cetera.
Sure. I'm happy to talk with you about that, and anybody else. I have a kind of form use agreement that I've used.
We have so many groups that use it, and right now I'm really concerned after listening to some of the things that I want to have the right terminology in our agreements that, with recovery recovery groups, you
Yeah.
know, recovering from addiction. We have
Yeah.
things like that.
Yeah, and yeah, I'll try to pull that out. I've actually put it together for some parishes,
Mm-hmm.
not in a while, but somewhere in my bank of Google Docs, I've got a form use agreement.
I'm curious as to maybe that could be added to our diocesan resources online, so that all church, because that's where I've been looking and I didn't find anything. So, yeah, but that might be helpful.
Okay.
Thank you.
Yep.
Susan?
Yes, I wasn't going to take the time, but tagging on to that, we have 2 spaces in our church that are being currently utilized. So we have developed what's called a license agreement, which gets away from the lease or rent, and it's very specific about what kind of access they can have. Would you be willing to look at that for us? I mean, we spent a long time on it with the language and so on and so forth, but it would be wonderful to have another lens.
Sure, and that's, you know, whether you want to call it a license agreement or a use agreement, I mean, it's essentially a contract that basically says, this is what you can use it. These are the areas you can access.
Yes.
You know, these are the hours in which you can access it. You're not giving one of your sticks. You're basically just giving somebody a contractual right to use, whether you want to call it a license or a use. But yes, I'm happy to look at that. Yeah.
Okay, great. Could you put your email in the chat maybe, or
Why don't you send it to me, Susan, and I'll get it to Don.
Yeah.
Happy to do that.
Yep.
Thank you.
Thanks a lot, Vicky, because when you ask me to do anything in the chat, I'm bound to mess it up. So
No problem. Elliot.
Donnie, I was wondering if you could just point out in a general way, what are the most common ways parishes get themselves into trouble with respect to these principles that, you know, that you've seen in your experience?
yeah, I think historically, you know, because parishes are doing good works and helping people, maybe some marginalized groups, maybe because this is coming from a emotional and heart place as opposed to a head place. They haven't I dotted and T crossed to protect themselves with, you know, documentation that basically, you know, to use recovery groups or any, you know, they haven't put into place they've just said, sure, you know, use our parish hall on Monday nights, as opposed, because again, it's coming from a heart place. It's not coming from a head place, where I would say that's just great, but make sure you have a piece of paper that defines what it is you're letting them do. And, you know, because that's important, you know, with your own, and to make sure you have appropriate insurance in place, property and casualty insurance in place for your facilities. I presume, do you mostly go through church insurance, or I know some places have their own, you know, they have people in their parishes who are brokers and they do that, but I guess most of us go through church insurance.
Yeah, every church is through church insurance.
Okay.
Bishop Doug?
I'm aware we have a couple of our Lutheran brothers and sisters on this Zoom, and you know, we really work together, and we're going to work together more and more as the years go by. And I was wondering, from their point of view, is this a lot different than your experience in the Lutheran Church, or is it similar?
Well, this has never been a strong suit of mine, so I'm not sure I'm qualified to answer that. I think pretty much we're the same. I was curious to hear that the priest or the rector is not a member of the congregation, because my understanding in the Lutheran sense is that we are. But that could be a misconception on my part, so.
I mean, I can say this about the Lutherans. You guys all got yourselves incorporated right when you started. So you're not kind of going back and trying to create things, so that when we did the merger between Christ the King and Epiphany, I had to create Epiphany, but Christ the King existed. And you also have your own, each of your organizations has their own set of bylaws, which, as I said earlier on in my talk here, in our diocese, and in your case, the Lutheran organization was the surviving organization. When two things merge, there are two ways of doing a combination of entities. One is a merger, where one entity ceases to exist, and the other entity is what's called the surviving entity. So A is merged into B, B survives. The other way is A and B get together and they create an entirely new entity, C, that is a combination. It's A to B to C is a much more complicated transaction than A to B, where B becomes A and B together, but B is the surviving legal entity. And it's different. When we did Sheffield, the Episcopal entity was the surviving entity. However, and I don't want to kind of, there is a separate agreement, what's called a federation agreement, that governs, even though Christ the King legally was the surviving entity, and we did change its name, but legally it was the surviving entity. There is a document that governs the relationship between the Episcopal entity that was merged into the Lutheran entity and the Lutheran entity. And in both in Wilbraham's case and in Sheffield's case, we did do those federation agreements. I didn't want to confuse everybody, but that's.
I've been living with it a year and I'm still confused by it, so.
You get to be both a Lutheran and an Episcopal at the same time.
I'm a dual citizen,
That's
and
right.
I love it.
That's
right.
great. Well, we're at time, friends. It's funny how an hour can fly when you have so much to learn. Carol, can you get it in 4 minutes wire?
Yeah, quickly. Building use agreements, Don. How often should they be renewed?
They certainly should be renewed if any of the terms change. Let's just say it's an agreement that says you can use part of your parish hall facility or whatever. You can use room A, B, and C, and you can have access to the bathroom that's there. If that expands, you should definitely change that. But I'd probably look at it every maybe 3 to 5 years generally, just to say, okay, you've been meeting here, AA or NA, or you've been meeting here for the last 3 to 5 years. Let's take a look at it and see where things stand and see if there's anything we need or want to change. Yeah.
Okay.
Yeah.
Thank you.
Thank you, Donnie. This has been wonderful, very rich. And I hope all this talk of canons is getting everybody in the mood to have a convention, because we've got one of those coming this week. And in keeping with all things Episcopal this year, kind of our theme, we're gonna have a little jump into history in December. So I put that in the chat to remind you of the date and the time. Father Michael Tuck will be on for In the Beginning, a little Episcopal history. Bishop Fisher, I think we're ready to go.
Okay, and just too, there's sometime in the near future, we're gonna have a Zoom meeting for people with large church buildings and on the challenges and the possibilities of having large church buildings. So that's I think it was scheduled for next week, but we're delaying it a little bit and get more information out on that. Right. So I don't see any deacon on here. Any deacon on this call? So I'll be the deacon. Go in peace to love and to serve the Lord. Alleluia, alleluia.
Thanks be to
Thanks be to
God.
God.
Hallelujah,
Hallelujah.
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 Thanks, Donnie. Thanks, everybody.
Welcome.
Thank you.
Bye-bye.
Bye.
Great
Bye-bye.
job, Don. Bye-bye.
Take care.